amazing. Everything, camera's really kind of annoying me. I'm gonna have to fix it later. Sorry. I don't know if the OCD people watching is gonna bother them, but what's up? What's up? Welcome back. Let's see, man. I feel like today's just like all over the place. It's kind of annoying because they literally, like, after I got off, I don't know how long was it, like 10 minutes after they released the video on Court TV. And so right now they're doing their thing. Fuck, this shit's gonna irk me. Let's see here. How do I do this? Full screen. All right, so we got that. We're gonna watch this in the meantime. Right now they're still having the Associated Press. The Associated Press is going back and I feel like the couch. That shit is so irking me, yo. The Associated Press right now, they're going at it right now. The media coalition, which I think they waited till I got off to post the shit. It took all day long. They're still going at it right now. There's some really heated arguments in exchange. Apparently Mo told me that, let's see, they're arguing cameras in the courtroom right now. So the plan is, what we're gonna do, we just have to adapt, and we're at their mercy. The media coalition. The media coalition, huh? Yeah. We're at their mercy for when they decide to release the footage. We're gonna watch the video that I didn't see earlier. A lot of you guys probably saw it. I didn't see it. Let me fix this chat going. Media coalition. We've come together to fight. All right, let's do it. You guys ready? Let's start. Kohberger. This is from earlier, okay. And Taylor, whatever her name is, Taylor Smith. He trimmed his eyebrows, really? Oh, he did. He does look like he trimmed his eyebrows. That's part of the evidence they're gonna use against him, right? Because the surviving person said he had bushy eyebrows. Tony, thank you for the membership. One more member here and here. Amazing. They ruined the entire plan day. I love it. Man, more serious too. I mean, what else is it gonna look like, right? Gel out his hair, freshly shaven. Trying to appear confident. He loves the attention. Look at that. He even smiled. He even did a, what do they call it, a fracture smile? Half smile? It's beyond boring. This is boring? Tampering with evidence if he cut his eyebrows. Probably, yeah.
All right.
All aboard!
Thank you very much. Please be seated.
And so whenever the new video comes out, because I heard this one is actually pretty good. The one that's coming up, whenever they decide to release it, I actually heard that's pretty good. The judge is getting snippy. That judge, he's kind of, I don't think he wants the cameras in the court because I don't think people are gonna like that judge. He's a little snippy. Oh shit.
I am sorry.
Oh.
All right. That's awesome. All right. This hybrid approach is.
Yeah, he kind of nasty, man. I want to hold my I want to reserve my thing until we see the new thing, but I heard he was a little snippy. You trying to look normal?
So let's get on the record, please. We are now on the record. This is State versus Bryan Kohberger, CR 29222805. We're here for a hearing on the Goncalves family's motion to appeal, amend, and/or clarify amended dissemination order that was filed back on February 3rd, was delayed because the media sought some relief from the Idaho Supreme Court. There was a delay to find out what the Supreme Court was going to determine, which they did. And
say he's a good
morning,
judge.
We have the state represented by Mr. Thompson and Mr. Rudley. Mr. Kohberger is in the courtroom, represented by Ms. Taylor and Mr. Logston. And I believe Mr. Gray is, there he is.
Let me sit back here, Your Honor.
And I believe some of the family is participating, observing on Zoom. So before we get into the arguments, I want to address the Goncalves family and all the families, really. Didn't really have an opportunity to do this at the arraignment. My heart does go out to the families. And the loss to your children is devastating and horrific. I mean, there's no dispute about that. I also want to acknowledge and apologize because at the arraignment, I did stumble over a couple of the names, Kaylee's name and Raymond's name.
Pretty bad audio.
And I want to explain that. I was up all night, really ill, probably food poisoning.
Oh, what?
And I was not at full potential. Probably also some emotion and nerves as I read those names. And I'm sorry. So that's my apology for that. I know some people were concerned about that and I wanted to address it. I also wanted to explain a procedure at the arraignment that apparently drawn from the media that some people were confused when Mr. Kohberger declined to enter a plea. And I just wanted to clear that up because I didn't really see any explanation about that in the media. That is Mr. Kohberger's right. And under Rule 11A1 of the Idaho Criminal Rules, and this is a quote, if a defendant refuses to plead, the court must direct the entry of a plea of not guilty. That is.
Okay, so Mo told me it's over, the other proceedings, so now we just wait till they post it. So I guess in like 5-6 hours later, some bullshit. We'll see when they post it. Hopefully like within an hour. I think earlier today, I streamed for like an hour and, 16 minutes or something? It's so annoying to me, everything got thrown off today. But that happens though. So we streamed for an hour and 16 minutes. And then right as I got off, about like 5 or 10 minutes later, they posted the shit. So, all right.
Not unusual, but reading the media, it seemed like somewhat mysterious. So I wanted to explain that, particularly to the media. It's a small issue, but it's somewhat, well, I think that I have an obligation, just as the media has an obligation, to help to educate the public about the processes that we are responsible to follow in the courtroom, and that's important for journalists. That's also important for the citizens. So, if you're curious about that, you can always find the criminal rules on the Idaho Supreme Court website. And it's very, very easy to read them and maybe get a better understanding. All right, so that's my speech for today. Mr. Gray, come on up. And
If you allow me just a minute or two to get started out here.
Take your time.
Thank you.
Thank you, Mr. Gray.
Can I proceed, Your Honor?
Yes. Thank you, Mr. Gray.
First, Your Honor, we'd like to thank you for apologizing to the victim's family. I think it was an emotional day for them, and they appreciate your apology. I know that they took that part up. Thank you. I would first want to start with a procedural history of this non-dissemination order, if I could. On January 3rd, 2023, the Judge Marshall submitted a non-dissemination order. And in that order, it applied to parties in the action, which would have been the prosecution, the defense, and any agents, investigators involved in it. After that non-dissemination order was issued, I reached out to the prosecutor's office to see if I could get Judge Marshall's email. For some reason, I don't know if they took it down, but I couldn't find it online. And they informed me that they were not privy to give me that information. Then, on January 13th, there was a Zoom call that was requested by Judge Marshall. That Zoom call was requested at 1 o'clock on the 13th. I received an email at 12:58 from Judge Marshall's clerk requesting a Zoom call to speak to all interested parties. The Zoom call occurred at 4 o'clock p.m. During that meeting, the judge reminded us, all the parties involved, it was the prosecution, it was the defense, it was myself, it was the attorneys for the victims' families, the attorneys for the witnesses, I believe were there as well, a number of attorneys, and reminded us that her non-dissemination order mirrored that of Idaho Rules of Professional Conduct 3.6. As part of that hearing, and I think it's details here, she talks about the rule applies to all lawyers participating in the Zoom meeting, the state and the defense and all attorneys for the witnesses. When she had that Zoom meeting, and I've requested the transcript from that Zoom meeting and haven't been able to receive it yet from Judge Marshall's court, so we could have a full transcript of what went on that day. But as part of that meeting, I had questioned Judge Marshall regarding the victim's family and whether or not they were allowed to speak to the media based on the fact that she had said all interested parties as well in the initial non-dissemination order. I didn't receive any clarification. I was just instructed to go back to Idaho Rules of Professional Conduct 3.6, as well as I was told, and this is in quotes from her Zoom release, take their duties in utmost regard in conducting themselves and advising their clients. I took that as I should tell my clients to be quiet. She reiterated that again in the Zoom call by saying that I had ethical duties strived above in the Idaho Rules of Professional Conduct for commentary of Rule 3.6. And she reminded me later that lawyers have a responsibility in giving advice to their clients.
They were saying that. So I saw somebody here saying that. Where was it in the chat? Gamer Lover says Court TV chat all talk about the shoes. Somebody sent me. I guess this was a tweet. So everybody's talking about his shoes. I guess the shoes look nice to me. What's wrong with the shoes? I don't know. It's not. Is that maybe not appropriate? Somebody said, so I'm not one to demand French cuffs and silk ties, but every privately retained attorney appearing in court, but the bar needs to be higher from Shannon Gray's lifted plastic tan boots. Is that plastic? Oh, Lord. I thought that was like suede or something. Lord. With no socks. Really? Damn, they looking that hard? They said no socks? Maybe Judge, I forgot the judge's name, could address that in his order. Oh, Lord.
I disagreed with Judge Marshall on almost every point during that meeting. As well as, if I had known that we were going to be discussing the Idaho rules of professional conduct in that issue, I would have prepared. But only having a 3-hour notice didn't allow me, and not knowing what the subject of the meeting was going to be, didn't allow me to address those issues at that time. Now, after the non-dissemination order in January 3rd and then the January 13th, 2023 meeting, the judge amended the non-dissemination order on January 18th. And she basically repeated the same order, except for she added the attorneys for any interested party in this case, including attorneys representing witnesses, victims, or victims' families, as well as parties to the above entitled action. So you can see the difference is that the first one dealt with parties to the case. The second one went way over the top, addressing all attorneys that might be associated with the case, or any attorneys that might have an interested party in this case. So that's where we are today. I filed a motion based on that additional language. Now, I'd like to get into some of the issues here. It's very clear that I am not a party to the case and the victims' families are not a party to the case. That's very clear through all of the case law, as well as...
Oh, shit. Look at Joe. What is that?
Can I interrupt you?
Yes.
There's no dispute about that.
Okay.
Oh, okay. He frisky. Okay, he frisky. And they zoom into the face and everything.
You're not...
As...
Can I interrupt you?
Yes.
There's no dispute about that.
Okay. Then
your clients are not parties. The only parties of this case are the state and Mr. Kohberger. That's clear in the case law with regard to any victims or victims' families. There are constitutional protections and statutory protections for victims and their families.
I would agree.
That's well established.
So let's get into...
I think he's just trying to reiterate his point to try to argue why there shouldn't be a gag order on them, I guess, or the family's attorney. But he frisky. All right. And I heard that he got even friskier in the new video that's coming out. Whenever the media coalition decides to release it. When we're ready, we're gonna drop it.
The actual non-dissemination order itself, how it addresses to me personally as the attorney for the victim's family. This non-dissemination order, of all of the cases and all of the motions that were filed, and referencing every case that was listed in this case, none of them apply to a victim's attorney, an attorney representing the victims. The Idaho v. Tapp case was an attorney speaking about a judge who he was in front of. The Good case was a defense attorney that spoke to the media. The Mezabov case was a defense attorney and a prosecutor. The Morrissey case was a defense attorney and a press conference. Varner versus Delahanty was an attorney and a judge, all parties to the case. Cutler was a defense attorney, U.S. v. Cutler. Zhao versus Flock was a defense attorney. Irwin versus Dowd were the prosecutor's actions and speaking to the media. Shepard v. Marshall. Maxwell is a trial publicity regarding the prosecutor's actions prior to trial. None of those things apply to the victim's family or the victim's attorney in any way. Now, I do agree that the court has the power to control those that are parties to the case and that are involved in the case in some way. But we have to define that. What means involvement in the case? Part of that is that the judge referred to the Idaho Rules of Professional Conduct 3.6, trial publicity. She references that multiple times as the basis for her non-dissemination order in this case, and how it might apply to me. If you read the first paragraph, a lawyer who participates or has participated in the investigation or litigation of a matter shall not make extrajudicial statements. That is not me. It never has been me. It can't be me, because I'm not involved in the litigation. She also says
Can I ask you a question about that? Because, I mean, I think the case law is quite clear that attorneys who are representing witnesses can be restricted to some degree, partly because they have access to particular information that should not be shared with the public. And if I'm recalling correctly, the state has suggested or has determined that your clients are witnesses potentially. So that's kind of the issue right there. Go ahead.
As part of that is that, let's just make it clear, the victim's family has never been involved in this investigation, ever, from the get-go. After Mr. Kohberger was indicted, we received no information about anything regarding the prosecution. Nothing. They wouldn't even tell us that a grand jury was being impaneled for Mr. Kohberger. They told us that there was a grand jury that was being impaneled. And common sense, we figured it out, because he's the only guy in the county. But they wouldn't even relay that information. They haven't given us any information regarding the investigation of the case. But the most critical part of it is that the prosecution has never, ever interviewed the Goncalves family. So how in the world would we ever be able to be witnesses in this case? And for what purpose would we be? If you're asking about for sentencing purposes, that's post-conviction. That's after he's been convicted on the case. Prior to trial, we're not any witnesses. And that falls into completely different statutes. That falls into the restitution statute. It falls into the victim statute. I just handled that matter in front of the Lloyd Vallow case, where the judge, I had a motion, the defense did not want the victim's family to appear. And so the judge had to make a determination whether they were immediate family, because it was the grandparents. Completely different statutes, because that was post-conviction. And those witnesses were allowed in the courtroom and were involved in the sentencing aspect of it. Okay? So we are in a very, very different factual situation here. I'm not asking as a witness to the case, which witness to the case, they never ever told us in any way how we would be witnesses in this case, other than the conjecture that we may have potentially. That's not good enough to stop the free speech of the victim's family, as well as myself. The other thing is that if the victims can say whatever they want during the free speech, and that's exempt, why would I not be allowed to say the same thing that they say?
My understanding is that your clients are not restricted in any way, never have been.
Well, I'll give you an example.
I mean, is that true?
That's right. Well, I agree now, because that's not the tone of the Zoom meeting.
Well, we're not talking about the
tone.
I'm talking about the language of the order.
Yes, the language of the order now, because any interested parties, I asked for clarification, now I understand that they can say whatever they want. And that's correct. But here's the problem. If they said, we think the judge is crazy, would I advise them against that? Absolutely.
Thank you.
But if I went and said, the family has said that they think the judge is crazy, there's nothing wrong with that. I'm repeating exactly what they said. Now, what comes into play is, for our purposes today, is what if I offer up my own opinion? Right? Well, then I'm already governed by the Idaho Rules of Professional Conduct. And if
I'm glad you're acknowledging that.
No, well, every attorney is, Your Honor. I mean, it's not.
Thank you.
Every attorney is. So I'm not, but every rule doesn't apply all the time. If I'm talking poorly about a judge, another rule might pop in. 8.3, I think, is what it is, or 8.1. If I'm saying other things that might affect things another way, then maybe the probabilistic. But the probabilistic I don't even think applies to me in this anyway, because if you look at it, it says it applies to a lawyer who is participating or is participating in the investigation or litigation of a matter shall not make extrajudicial statements. And it goes on, highlighted by Judge Marshall, then in paragraph 3. The rule sets forth a basic general prohibition about lawyers making statements that the lawyer knows or should know will have a substantial likelihood of materially prejudicing the adjudicated proceeding. And at the bottom of the paragraph, it says this. Rule only applies to lawyers who are or who have been involved in the...
Yeah, the audio isn't too great. 100%. I guess that's just how it is. I wonder, let me try something else real quick. Let me see. I think they only had one feed, but let me see this real quick. Let me test this other.
I took that as I should tell my clients to be quiet. She reiterated that again in the Zoom call by saying that I had ethical duties.
Is that a little better?
And I have rules of professional conduct for commentary of Rule
bump it up.
3.6. And she reminded me later that lawyers have a responsibility
better or
to
the
give
same?
advice to their clients. I disagreed with Judge Marshall on almost every point during that meeting. As well as if I had known that we were going to be discussing.
I mean, I think that one sounds a little clearer to me. Or just that's quieter. It's the room. Yeah, no, there's not much. That's a little bit better. That's noise. All right, hold on. Give me a second. Let me just switch it. So we're at. Let me see how far we are. 2052. Let me just switch the feed here. 2052. I think it sounds a little bit less noisy. And also, I'm worrying about the status of how long they're going to take with this other video. I hope for my sake they don't take forever. Okay. I'll put myself here. All right. I think this one's
a non-dissemination order that restricts First Amendment rights, that is overly broad in almost every aspect of it. Anybody that's interested and they have an attorney. When an attorney who's walking down the street could offer up his opinion in any way. It also takes away from the idea, doesn't the court want victims' families to have representation, to guide them through the legal process? Wouldn't the court encourage that? That they could explain things, say, maybe advise them on what to say, what not to say? I mean, if you're taking my voice away, you're taking the voice away of everything. The other part of it is this, is that I'm absolutely blown away that the prosecution doesn't agree with me in this case. The reason being is that they are representing the victims, which in turn are the victims' families. And I have not seen a poorer line of communication in my 22 years of practicing than the prosecution's office and the Goncalves family. And I think it stems from, initially we were critical of the investigation. They wanted to find the person who did this. That's normal emotions. And then from that point on, it has been, we are the enemy. And that's how we feel in this. And so, me guiding them and then trying to limit my voice and helping them out in some way, and then throwing out a random idea that they may be potential witnesses when they've never ever interviewed them in any way, it's just an attempt to shut the attorney out and shut the family out, is what it is. Because if I had come to you today and said, we've given 7 interviews, Your Honor, we may be witnesses in this case, we've done all of these things, it may be a different story. We haven't done anything. They haven't interviewed the entire family. So,
well, I don't know what's in all the investigation, obviously, and a lot of us don't know and probably won't know until the trial.
And the other thing,
well, let me just say this. I think one of the potential issues is this is potentially a death penalty case. Hasn't been noticed, but that is a potential. And the families of the victims certainly
Thank you, Judge
would be
Johnson.
witnesses in that process of sentencing. Now, that is not post-conviction technically, is it?
Well, if your goal is fair and impartial jury, right, that's the reason for the non-dissemination order. Well, after the conviction, that goes away.
Well, it's also confidence in the process. So I have that job. I have a job of protecting and preserving the First Amendment and also the Sixth Amendment. And there is some balancing there. That is why lawyers who have access to information that is not accessible by the public have particular restrictions. That's what this whole case is about. I mean, this hearing is about.
And as an officer of the court, I can tell you we have zero access.
Okay, so you're saying that the prosecutor's office has not shared information with your client.
Regarding the facts of this case, no, they haven't.
All right.
How things occurred.
Everybody's going to have a chance to weigh in on this, and I just, you're helping me understand what the issues are, so thank you.
Well, so that's really the issue here. I mean, and this is an important ruling because what you're doing is this has never happened before, ever has it happened before, that a Judge Marshall, has tried to silence the attorneys for victims. Never has it happened that I'm aware of.
Would you feel more comfortable if there was a more concrete description of what people could say and what they can't say?
I don't think you have the authority to, Your Honor.
Well, I think I do have the authority.
Shit.
Argument is that part of the argument is that
Of what people could say and what they can't say?
I don't think you have the authority to, Your Honor.
Well, I think I do have the authority.
Well, my argument is that part of the argument is that
In fact, I know I have the authority to do that.
well, and the authority would be through your the attempt to have a fair and impartial jury, that you can control people that are involved in the case, correct?
That's part of it.
And we're not involved in the case.
Okay, that's hard to accept, but
Or we're not witnesses in the case, we're not involved in the investigation, we're not involved in the litigation, I can't file any motions, I can't subpoena anybody, I can't cross-examine witnesses, I can't do anything. So this idea that there's this loose idea that there may be, weighing that versus our freedom to speak, First Amendment, is...
we're talking about your
That's right.
speech.
That's right.
Not your client's speech.
But that is my speech, that is part of it though.
Well, in your memorandum, you are suggesting that you also have an independent position, that you are representing yourself.
I do.
It's distinctive from your responsibility to your clients.
That's why the motion is for amending or clarification, because there's the clients that have the free to speak. There's me repeating what they have to say. If they said the judge, we thought the judge was crazy, and I said the judge was crazy, I can't be, it doesn't violate the non-dissemination order because I'm allowed to say that. And then there's my independent voice, where I said, the judge is crazy? Yeah, I think the judge is crazy. That goes into another layer, right? Where it would be, Idaho rules of professional conduct would fall into play, and what I would be doing or what I couldn't do. Not the non-dissemination order, because we're not parties to the case. I'd be governed by the Idaho rules of professional conduct if I made those statements, extradite those statements. And I may or may not fall under the trial publicity. I would argue that I don't, because I'm not a party to it. I'm not litigated it, I don't have any information on it, none of those things. So really, that's where the authority for me, for my voice, would come from the Idaho rules of professional conduct, if I did that. And if I made a statement that I thought didn't apply for trial publicity purposes, that would be an argument for another day. But it wouldn't be for you, for a contempt of court for me, because I'm not a party to the case and I'm not involved in the case in any way. I'm just repeating what my clients say, or I'm just saying my own individual opinion, which doesn't, by the way, makes it absolutely unduly prejudicial. Because what if a guy is on an Idaho bar member, is walking down the street, looks up, sees a television program where the Goncalves family says, well, we thought the judge was crazy, right? And then all of a sudden, the media is outside, they interview him, they say, hey, you're an attorney here. What about the judge being crazy? Well, I've been in front of him 3 or 4 times, and I would agree with him. You're going to sanction him and contempt of court? You can't. Same as me, because I'm not a party to it. He's not a party to it. He might be governed by the Idaho Rules of Professional Conduct by commenting on you, Your Honor, but it wouldn't be because of the judge's non-dissemination order. So how can it not apply to him, but it can apply to me? It can't.
Well, the case law suggests that because you represent potential witnesses, that you have access to information that may not or should not be shared with the public. That's what the case law says.
And I would argue this: what potential witnesses are we, number one, and what access to information do we have? I think the defense has argued that we have some sort of access because the clients can tell me whatever they want to tell me, right? Well, that's free speech. They can say whatever they want to me, and I can go off and say whatever I want that they said. Because it's free speech. It's the First Amendment. So you can't, I mean, this non-dissemination order is so broad, none of the case law applies to people that are outside of the defense or the prosecution. That's the point of it. That's the whole point of a non-dissemination order, because they have access to it. They have access to the information. Victims, attorneys, families do not. And the idea that we may or may not be a potential witness is enough for Your Honor? I just can't see that, especially when there's no history of them ever being a witness. And to tell you the truth, the day after they filed that notice, or the day before they filed the notice that we may be potential witnesses, we had just gotten out of a meeting with the prosecutor's office, discussing whatever we could discuss, like our concerns, because that's all we do is go in and talk about our concerns, and they tell us, we can't say anything, we can't say anything, we can't say anything. We'll get to it. When we walked up, nowhere in that meeting were we described as being witnesses in this case. But all of a sudden, the next day, they thought we might be, even though they've never interviewed us. So, they're throwing stuff in the air that is not justified, and the idea that he thinks maybe might is not enough to regulate my free speech in this as the attorney for the victim's family, because that's what we are. We're not attorney for witnesses, we're attorney for the victim's family. And if the court has any other questions, I'd be more than happy.
I understand your position.
Good.
Thank you, Mr. Gray. So let me go to the state. I don't know if that's Mr. Thompson or Mr. Rutland.
Don't be me. Can I have one comment, Your Honor?
Certainly. Thank you.
Your Honor, if I may,
Yes, you may.
Mr. Rudley is actually going to be arguing on the motions themselves, but as attorneys, we have a duty of candor to the court. Mr. Gray has made representations to the court that at best are misleading and in many ways simply untrue. And I need to correct them for the record. Because the media is here. I do not want the public to come away with the impression that improprieties have occurred. First, Mr. Gray, on behalf of his clients, has propounded a number of questions to our office and to the investigators. We have answered the ones that we can. We have not shared ones that we are concerned that Mr. Gray or his clients will be public and compromise the integrity of the investigation. For him to say that we provided no information is simply not true. Secondly, he claims that law enforcement has not interviewed his clients and that somehow that is the investigator's fault. In fact, from the very beginning, the investigators have attempted to interview his clients, and Mr. Gray has not permitted it. So just for the record, I want to make sure that's clear. Thank you, Your Honor.
If I could speak to that, Your Honor.
You'll be able to.
Ooh, what he was saying? He was saying, ooh.
Back in
That's the prosecuting something down?
after you
Oh,
hear
good.
the other
Thank you.
arguments. Mr. Redland, go ahead.
Ooh.
Thank you,
Okay.
Your Honor. In State v. Spencer, the Idaho Supreme Court noted that it is also the duty of the prosecutor to ensure the right to a fair and impartial trial. Under the dictates of Shepard v. Maxwell, the court has a duty to take affirmative steps to address the impacts that intense pretrial publicity can have on a case. As noted in Shepard, Nebraska Press Association versus Stewart, and their progeny, an order like the one in this case is an appropriate measure for addressing that duty of the court. As Mr. Boston's experts have noted, attorneys often have information about a case that may not be appropriate for dissemination in the press. Additionally, attorneys carry a greater weight when appearing on television. For instance, what might be easier for the parties to address is a juror that says, I've seen coverage on the case, but I don't always trust what I've seen on TV, and I can set that aside. What's more difficult is a juror that says, I've seen attorneys for the prosecution, attorneys for the defense, or attorneys for the victims on television talking about a critical aspect of the case. In the matter of Gentile versus State Bar of Nevada, that case involved an attorney who held one press conference in 1991 after the indictment of his client. In this case, Mr. Grace repeatedly issued statements and been on television. At minimum, it's insincere to argue that he's feeling bound by the order when it's clearly not abided by. In Gentile, the court noted that the speech of attorneys is subject to less substantial, or it can be regulated by less substantial means. In this case, as we've shown by the affidavit we filed, the Goncalves families are potential witnesses in a trial, or more specifically, at sentencing. The order in this case is not vague, overbroad, unduly restrictive, or not narrowly drawn. It precludes all extrajudicial statements of the attorneys in this case, attorneys for the witnesses, victims, law enforcement, and investigators. The order addresses, if the court were to apply strict scrutiny, the order addresses a substantial likelihood that pretrial publicity poses to the integrity of the judicial system, and is tailored to ensure that the rights to a fair trial are upheld. As we briefed in the case of Levine, the alternatives such as sequestration of the jury or changing a venue aren't going to mitigate the impacts of statements, extrajudicial statements in this case, and are unlikely to do so. Thus, the state contends that the order is an appropriate measure of the court to uphold its duty under Shepard, Nebraska Press Association, and the like to preserve the right to a fair and impartial trial. At a minimum, Mr. Gray's statements that he's not bound by trial publicity rules or 3.6 in this case illustrate why the order of the court is necessary in this matter. And so we would ask that the court uphold the amended non-dissemination order, or at most tailor it to those statements specifically precluded in Rule of Professional Conduct 3.8. And with that, I'll stand for questions.
Thank you, Mr. Redley. Yeah, do you think that would be helpful to just, and I asked Mr. Gray this same question, would it be helpful to say, okay, you can say these things, but you can't say these things, and be more specific about that?
Your Honor, our initial position is that the total prohibition of extrajudicial statements is the safest and most responsive way in this case to address and preserve the right to a fair and impartial trial.
All right. Can you go back? You mentioned this about the standard particularly applying to the lawyers who are somehow connected with the case.
Yes, Your Honor. In Nebraska Press Association v. Stewart, it's noted that I believe Justice Brennan states that there's no doubt that the court has authority, though it's in a footnote, it's no doubt that the court has authority to regulate the speech of attorneys, witnesses, and other participants in the court process. At this point, the evidence that's been provided is that the family would be potential witnesses in the case, as Mr. Thompson mentioned. We haven't necessarily been able to make a full assessment of that, but undoubtedly they'd be witnesses in any sentencing.
And what about the standard? Strict scrutiny or lower standard?
Your Honor, we would argue that the court should apply the standard in Gentile versus State Bar of Nevada, where the Supreme Court stated that, I don't want to mess this up, so I'm going to go quick here.
That's fine.
That the speech of lawyers may be regulated under a less demanding standard. So we would argue that so long as the court finds that it has a duty under Shepard to preserve the right to a fair and impartial trial, that the order addresses the substantial likelihood that that negative pretrial publicity would have on that right, then the court would have authority to impose the amended non-dissemination order.
Thank you, Mr. Redmond.
Thank you.
Mr. Ross?
Judge, I think a lot has already been said, and obviously you wrote a lot in the briefing, so I guess I'll just touch on a couple of things. In terms of the argument that the victims' families are not involved in the litigation of this case and therefore don't fall into 3.6, it would be our position that if you have statutory and constitutional rights involved in this case, you're involved in the litigation. Regardless of whether or not the prosecution is willing to work closely with you or whatever issue you have there, the reality is if you have literal rights that permit you certain things that are involved in this case, you're involved in litigation, and therefore you fall within 3.6 just like everyone else. Second, the standard from Gentile is the substantial likelihood of material prejudice. I don't want to get too much into that, Judge. I think that's kind of this afternoon's argument. I think the main thing before the court, as far as Mr. Gray and the family, is just do they fall within this, and then the court to decide what is appropriate. But I would note that given the vast amount of media coverage in this case, and the fact that it seems like no matter what anybody says or does, in one way, shape, or form, it will be twisted into an attack on my client. We also agree that at this point the safest thing to do is for everyone to just not be talking to the media and allow statements to be made here where we all get a chance to speak and the media gets all that information. If they still choose to do what it is they've been doing, then that's on them. But we don't have somebody who's just trying to whip the media into a frenzy and send this case to the firing squad or however it is. So that's our main concern. The only other thing that I wanted to address, and the court addressed this a little bit, the reason we stand silent with grand jury indictments is because there's an old arcane rule that says that if you have a grand jury indictment and you enter a plea, you are accepting the validity of the indictment. haven't seen a prosecutor try to use that in a long time, but we can avoid any possible claims that somehow we can't challenge anything with the indictment by simply standing silent and having the court enter the plea. So just so that everybody's clear, that's why we do that. Does the court have any questions for me?
I don't think so, but thank you for that additional education.
Thank you.
All right, Mr. Gray, it's your motion, so you can respond to what other counsel expressed. Thank you.
I guess the first thing I would want to address is the prosecution's idea that I haven't allowed our clients to speak with the investigators. You'll realize that the date of the incident, I wasn't retained on this case until close to December 5th, which will be more than 3 weeks after the incident occurred, and they still have made no contact as far as investigating and interviewing the victims' families. So somehow that I precluded that in some way is just not true, Your Honor. And as far as scheduling those things, I'll just leave it at that. The second part is, everyone is quoting the Gentile case. The Gentile case is exactly like all of the other cases. It says over and over, it has to be a lawyer participating in the judicial proceedings. It has to be a lawyer who represents a defendant involved with the criminal justice system, a lawyer actively participating in trial, a lawyer who's participating before the courts can only be limited if he's participating in front of the courts. None of it applies to me.
It seems like you're in court right now.
Because you're the one that brought me in here because of the non-dissemination.
You brought yourself in.
Yeah, well,
you're the one who filed the motion.
I did file the motion because the non-dissemination order is unconstitutional.
I understand. I'm just trying to clarify what you just said.
Well, this will probably be the only time I'm allowed because I won't have the authority to file any other motions on anything else in this case.
Why would you say that?
Well, because I'm not a party to the case.
You can still, I mean, the media is not a party of the case either.
Once again,
well, the Supreme Court has said they have standing to come into the court and address issues, so.
Yeah, but that's completely separate. They're not.
Well, I know it's separate.
Okay, so.
I also respect your position in representing the family's victim's family. And I respect that. And there are some constitutional issues, rights that they have. So I'm not just dismissing that.
And the mere fact that you have a right, I'm absolutely positive that the Idaho legislature and the Constitution, when they gave victims rights, didn't think that that was implementing those victims into the trial in some way. Absolutely positive that wasn't the intention of it.
Totally agree with that.
So this idea that if you have rights, then you're involved is just beyond. That being said, Your Honor, nothing precluded the prosecution from contacting my clients well before I was representing them. I had almost 3 weeks to contact them. I think, don't mark me on this, I think I was retained on December 5th. I think that was the day. I don't have my file in front of me, but it would hold me to it. But I think that was the day. So they had plenty of time to contact my clients and interview them if they were going to be potential witnesses in this case. And since then, every time we have had a meeting, we have initiated that conversation. It hasn't been the prosecution initiating that conversation.
So are you saying since you have been representing your clients that the prosecutor or investigators have not asked for interviews?
I would say this. In the meetings that I have had with the prosecution's office, I have asked, as part of that, whether interviewing my clients might be an issue. Would they like to do that in some way? I've offered that up in some way. And they've never
Answer yes or no. What's all this malarkey shit?
taken this up on.
And he's shaking his head.
Maybe a random email here and there that says something and no follow-up whatsoever about anything. So this idea that they are going to be witnesses in this case is just an attempt by the prosecution to shut them up as well as to shut me up. And by the way, people completely forget about this. All of the information that has been disseminated to the public from the get-go was the mayor, Art Bedke. Chief Fry had interviews. Bill Thompson had interviews. The coroner had interviews. All of those people had interviews. We didn't. We didn't until we started getting information and started trying to figure out what was going on after they had given interview after interview after interview. That was the purpose of the judge issuing the non-dissemination order, is to quiet them up, not quiet the victims up. They had no control over that investigation from the get-go.
Well, that order was a stipulation between the state and Mr. Kohberger.
That's the other thing, though, is that the court, after that Zoom meeting, Judge Marshall incorrectly said that that was stipulated by all parties. I never stipulated to that. I emailed the
You're
judge.
not a party.
Exactly right. I'm not involved in the
The
case.
stipulation was between the parties.
So-
As you correctly stated who the parties are.
So we would
I
ask,
agree, but you were suggesting that it was entered to shut down the prosecutor's office.
why would they
That's what you
claim?
just said.
I do think that part of the, that was part of the process, is that they understood that their investigation was getting out of hand. Too many people were talking in their investigation, and that's why they stipulated to it. Yes, I agree.
Okay, when you say they, you mean the prosecutor's
Yes,
office?
yes.
All right.
Do you want me to give you a final, or do you?
Go fight.
Okay.
You go.
We're not a party to the case. You're very aware of that. I have the right to repeat what my clients say to the media. I also have an independent right that I'm governed by the Idaho Rules of Professional Conduct regarding those individual rights versus my own opinions. But those opinions, I don't firmly believe, would fall under the publicity rule on the Idaho Rules of Professional Conduct, because I'm not litigating it or part of the litigation. And the reason those things are in place are because people that have real privy information regarding the prosecution and the defense, which I don't, which my clients don't in any way, it shouldn't apply, Your Honor. Thank you.
Okay, thank you, Mr. Gray. All right, well, I'm not going to issue a decision today.
Of course, why?
I'm going to issue a written decision. There is a lot of briefing, and I heard some very interesting argument today, and I'll get back to work and try to get a decision out as soon as possible. So, anything else we need to address before I adjourn? Mr. Thompson?
I don't think so, Your Honor.
Ms. Taylor? Mr. Monson? Anything else?
Yeah, Your Honor, we thought you'd probably want to issue an order and wait, but I guess we're just wondering if in the meantime, the order as it is remains in place.
Yes.
Thank you, Judge.
It remains in place until I address it. So, with that, we are adjourned. Thank you all.
Alrighty. Well, that was amazing. So, oh Lord. So, I guess the media coalition is gonna. I guess the media coalition, whenever they decide what they feel like it, they're gonna release the shit. Let me take a look at the websites real quick. Let's see. Stereotypically, they do it as soon as I get off the internet. As soon as I end the live stream. I'm not gonna end the live stream, but let me just say, hey guys, I'm ending the live stream. No, that's not gonna work, because if they're listening, they know. That shit happened twice already. The other week too, we did this 2 weeks ago. Same shit. So they got a representative watching. We're the media coalition. We're waiting. Get bastard, get off. Let me see. I heard it was kind of spicy too. The lawyer and the attorney got into it. We're gonna release it when we release it. Kohberger. I don't think they're gonna stream this shit, man. To keep it real, what they say, keep it a buck. I don't think they're gonna stream the shit. I don't know. If we're lucky, maybe they'll record it and then post it after. That would be nice. Scott Briggs says this country is a total joke. Justice system a joke. I'm done. Shit. It's all bullshit. Aliens. There was a new alien video that got uploaded by News Nation. Currently, humanity, the talk of the nation. It's all about the aliens. The most important topic of our time. Let's see. I thought I saw a new video come out. Military whistleblower wants claims to be tested. Cold.
Oversight Committee is in the beginning stages of planning a hearing on UFOs. This follows claims from a whistleblower that the U.S. government is keeping secret its studies of an extraterrestrial craft. Air Force veteran and former intelligence official David Grush sat down with investigative journalist Ross Coulthart, who's reporting for News Nation. Coulthart is an award-winning journalist and author who has reported for the Australian version of 60 Minutes, as well as other programs. He has spent years investigating the UFO question. Grush said the military has kept a UFO program secret from the public and from Congress for decades.
When you say crash retrieval, what do you mean?
These are retrieving non-human origin technical vehicles, call it spacecraft if you will. It's probably not the right parlance, but no kidding, non-human, exotic origin vehicles that have either landed or crashed.
We have spacecraft from another species.
We do, yeah.
The revelations have sparked up debate in public view and a slew of articles.
Are we finally ready to admit UFOs are alien visitors? Why is everyone suddenly talking about aliens? Stunning UFO crash, retrieval allegations deemed credible, urgent. Oh man. Forget about who's going to run for president or get elected, or the diseases, or Canada burning and the New York yellow skies.
Articles this week, some calling for full disclosure by the government of any and all information on non-human aircraft.
Yeah, right.
And the interest in UFOs may only intensify as Congress gears up for this hearing, when we could hear from David Grush.
It's fascinating too. This is a government-approved whistleblower. He went and got permission first. Hey, just want approval from me. Is it okay if I put this out? They're like, yeah, sure, it's all good. What kind of shit is that? Got approval of some PSYOP bullshit, some distraction bullshit. Yeah, no, yeah, you got permission. What are they up to?
This time testifying. Investigative journalist Ross Coulthart, who interviewed Grush, joins us now. And Ross, I got to tell you, the public reaction to this interview has been really strong and deeply divided between those who've long believed the government has such craft and those who believe that those who do believe it are wearing tinfoil hats. Are you surprised?
I'm not surprised in the least, Elizabeth. I think we're all entitled to be sceptical. I think what Mr. Grush wants, though, is for his allegations to be tested. I mean, one of the things I think that people need to remember is he has given evidence under oath to both of the intelligence committees in the Congress, the House Intelligence Committee and the Senate Intelligence Committee, and he's also given evidence under oath to the Inspector General of the intelligence community. And his allegations have been supported by the Inspector General as being both urgent and credible.
When you say his allegations were found, I mean, the IG is taking the complaint, it's urgent and credible. Is it urgent and credible that he suffered some sort of blowback for trying to make this public, or that his actual story itself about extraterrestrial craft is urgent and credible?
Well, what we do know is that in support of Mr. Grush's allegations, a number of people did testify in camera to the Inspector General, and they supported Mr. Grush's allegations. We know that Mr. Grush has given allegedly the locations of where these craft are stored, the names of the people in charge of the program, and the gatekeepers allegedly controlling access to that program, both from within the Pentagon and from apparently a private aerospace company.
And you did very carefully vet David Grush before you sat down with him.
Absolutely. Mr. Grush is, I've spoken probably to a dozen people in the intelligence community who've confirmed that David Grush is a person of absolutely impeccable reputation. He left the military in April with high commendations from his commanders, and as was seen by people earlier this week in the debrief in the article by Leslie Kane and
no,
Ralph.
I forgot today was Friday. I don't know why it doesn't feel like a Friday. I feel like we wasted Friday. I feel like Friday was a waste. Alyssa, thank you so much for the super chat. Says I Instagrammed you a video. Maybe you Instagram my other account. I don't really check the other one. The iCkEdMeL one. I check iCkEdMeL. Oh, there we go. There we go. I check iCkEdMeL personal. I don't really check the regular iCkEdMeL. I should get rid of it. I do have a lot of messages here. Holy shit. I haven't checked. I do see your message. Best video. It's not opening. Oh, I got to accept. All right, let me send it to myself. Yeah, I feel like we wasted time dicking around today, Friday, with this bullshit with the media coalition fucking with everybody. I mean, I'm being a little snarky and kind of annoyed with this shit. I literally have other stories I could have covered today. Let me send myself TikTok. Wasting my time with this bullshit today. We're the media coalition. We're here to take over. When we say it's right, it's right. Let's see if they release it. Nah, they ain't dropping that shit till I'm off. Yo, watch when I get off this shit and that thing's posted. Because I'm just gonna laugh. Let me see, do I have any notifications left? Do I have any notifications left? I gotta get off this shit. This internet. I'm gonna look this video up. I want to show this to everybody. I don't have notifications again. I think whatever we do tonight, we should just chill. If I come back later, we should just chill. This has been like too much today. Too much kind of like. I would have rather talk about the aliens or something, or whatever other funky stories are out there. That's Friday. Okay, I have 3 hours, maybe 4 hours, 3 hours to another thing. So if something, well, maybe we leave it for a chase. If there's a chase tonight, come back for it. Let me see if I can get this video. TikTok video.
So I forgot to circle them in the video I just posted. I'm so sorry. Huge brain fog. So here is the video with them circled. I am so sorry, you guys. Again, I'm not a professional. Of the alien sighting in Las Vegas, I'm going to show you in two different filters. First this one, but I'm gonna let you guys know. Remember he said that they had glowy eyes and a big mouth. Well, this, you will see this thing kind of looks like open up his mouth right there, and that's pretty wide. You can kind of see eyes and whatnot. And remember, we really don't know what aliens look like. So, and then they close the mouth, and it looks like it's just looking around and whatnot, okay? You just see it looking around. And now I'm going to show you in a different filter. Now I'm going to show you in a different filter what you couldn't see in the other filter. And this one's kind of clear as day, what I believe looks like an alien, but you will see it right there. with the black eyes and is staring straight. But throughout this video, it does move its head. As you see, it's moving its head slowly, kind of looking around. But I could be wrong. See, it's looking around, and it does open its mouth once. You'll see it. It's like, I don't know. It just kind of looks like an alien, but we don't know what aliens look like. Again, there's not really a clear video of what this guy's talking about, but you guys let me know if you see it. Other than that,
Doodle Fart said glowy eyes and big mouth. Oh, that's low. That's my eggs.
We'll keep you guys updated.
Bro. I gotta start adding sound effects in my videos.
Police call everybody will be talking about. Thanks.
That aliens.
Police call everybody will be talking about. Thanks for joining us here at 6 o'clock. I'm Denise Valdez.
I'm Brian Loftus. A family says something crashed into their backyard, prompting them to call 911, saying they saw creatures walking around.
Our 8 News Now investigators digging into this for weeks now. And tonight, our David Charns with the video you will only see on 8 News Now. David?
Right, Denise, sources telling Bay News Now investigators that several agencies believe something landed on this property. Now, before we show you that video,
not a joke. This is
just heard. You'll see something flashing on reporting.
You know what we could do too? We got this that they've been released more body cam, which you really can't see shit. They just released like video of just blacked out body cam. Amazing. And we could check that out. And also I want to see if the YouTuber uploaded a second video, part 2 to the part 1. The aliens. Yeah, I'm sorry guys. Today wasn't like a great day because I feel like we got dicked around a little bit, not really knowing when they were gonna post something. And so yeah. Everybody. So yeah, let's see. We have in a couple hours. We have another notification. Maybe we'll get a chase tonight because that's Friday. Maybe we'll get lucky, get a chase. Maybe we can have a drink. We'll have a little fun later. That's a lot of rolling the dice on shit. Ooh. Let me check one more time and see if they release this thing or not. I know they're watching, their representatives and shit. It's off. Do it now. Launch it. Go. Green light. Green light. Green light. You just asked me where's the bad guy drivers. I know we had so much yesterday. We'll probably never get anything for like a month now. It's gonna be dry. Aliens. Alien encounter. I was abducted by an alien. Alien. iCkEdMeL, that time when you joked around about that, my mother was abducted. I'm not unsubscribing. That was so distasteful. You know, I get shit like that. I get crazy messages all the fucking time. People just like pissed off about like a joke that I made. I used to think you were cool. I've been monitoring you for years. I had people like, I got like a complaint last night and somebody was like telling me over the years how they started disliking me, but they still kept watching me. And so, and the person wrote like a list of shit, like DMing me. I'm like, what's so? Just stop watching then. Like if you're so, I mean, why would you? If you're so upset, why keep watching? It's like odd, yo. Like a list of shit from like years ago, shit I forgot about. I'm like, damn. Like, do they take notes? Like, are they writing shit down in a book and a notepad somewhere? I'm like, god damn. I never forget. I'll always remember. Jesus. Anyway, oh, thank you. Thanks, Slapfish. It's new. I've never been into like jewelry before, but I just got to treat myself. I'm telling you, I was kind of shocked. I've had a couple of instances like that, and I'm like, damn. That's crazy because I'm not that upset. You know, like just move on. Then there's so many options. I mean, I appreciate the people that watch me, or maybe I say something one day that upsets you. But if you're that upset, like holding it for like years and shit, god damn. All right, let go. I remember when you said this 2 years ago. Jesus. All right, I guess I'm gonna get out of here for a little bit, and we'll see what happens tonight. I feel like we need to have a little fun or something. I don't know, to make up for like today. Even though yesterday was crazy as shit, right? We had such a wild, fun day yesterday. Even with the chases, people are like, "How can you have fun?" I mean, we hope that nobody's gonna die, but we're just having most of the time everybody's safe. But it's a fun, entertaining. People over there in Cali love that shit. People like at the bar watching. I heard people sometimes at the bar watching the chases. Thank you, Lisa. Appreciate it. DSM-5. No, watching 20 minutes. I know they're gonna do it. Call in the chase. I'm gonna take like a little mini break and get the baby settled. And we already ate dinner, but all right, guys. I'll hit you up. Love you. Bye. Bye. Adios. Watch the thing. It's gonna